Excellent. So that's the hush that tells me that everybody's had their lunch and they're ready to start the intellectual stimulating part of today's event. So my name is Dr. Dominique Della Pozza. I'm a senior lecturer here at the ANU College of Law and also a co-convener of the Electoral Regulation Research Network ACT chapter, and it's in that capacity as a co-convener of that network that I'm welcoming you here today. And we're very grateful to the assistance provided by the Electoral Regulation Research Network that's run primarily out of the University of Melbourne for helping us to put on this event. So today we are looking at campaign finance regulation, a troublesome area, and we have two excellent speakers to speak to us today. The first presentation will be on Unions New South Wales versus the recent High Court case, and it will be delivered by Benjamin Smith. And a second presentation will be by Phil Green, who is known to many of you as a former Electoral Commissioner of the ACT, and I understand from discussions over lunch, one of the few people in Australia who's actually had to had the experience of levying a fine for breach of this sort of regulation. So I might ask Benjamin if he would like to kick us off today, and I'm just going to give him the recording device.
Thank you everybody for coming out on a Thursday afternoon to talk about campaign finance reform. Thank you obviously to Dominique for organising this afternoon and asking me to speak. It's a real privilege to share a panel with her and Phil Green. There's so much obviously to unpack and so many things that we could talk about. We're smack bang in the middle of an election campaign. In the interest of us not being here until breakfast tomorrow, I will confine my remarks to just talking about Unions New South Wales and New South Wales, or Unions 2, which is the latest in a long line of cases that marries up the implied freedom of political communication and the issue of campaign spending. By way of a roadmap, I'd like to start by having a look at the legislation and getting an idea of the mechanics of how this thing under challenge works. Then having a look at the arguments for the parties. We'll take a look at the highlights from some, not all of the judgments, and then finish by asking what all of that really means for regulators moving forward. Before we do that though, Dominique thought it might be useful for some of the non-constitutional lawyers in the room to have a very brief crash course in the implied freedom of political communication. So let's do that. As the name suggests, the freedom is nowhere explicitly stated in the terms of the Constitution. It's been implied or read in on the basis that the system of responsible and representative government that the Constitution envisions requires a free flow of ideas between both the electors and the elected, and the electors and each other. The test that we use to determine whether any piece of legislation has unduly infringed that freedom was developed in the matter of Longy and the Australian Broadcasting Corporation. Some people may remember David Longy, former Prime Minister of New Zealand, had sued the ABC for defamation. But the test that comes out of that really asks two questions. Is the implied freedom, or is there a burden on the implied freedom? And implicit within that question is the sub-question, is the communication political? Because it's a restrictive right and not all communication will be protected. And then if the answer to that question is yes, then we ask, is the piece of legislation reasonably and appropriately adapted to a legitimate purpose compatible with the system of responsible and representative government prescribed by the Constitution? That's an awfully clunky way of asking is, does the law, or is the law consistent with the terms of our democracy, and does it do so in a reasonable way? Now that test was later developed further in a case called McCloy, which also dealt with campaign funding in New South Wales. And it added this structured proportionality which asks, is it suitable, is it necessary, and is it adequate in the balance? Now that McCloy formulation has been reasonably controversial, and there are various views about its utility among the members of the court. It's neither necessary, I don't think, nor useful for us to really get caught up in the minutiae of that today, but anyone who is interested can go and have a look at the judgment of Clubb and Edwards, which is the most recent implied freedom matter, and it gives a really comprehensive structure of when those questions are to be asked and how they're to be answered, when that test is to be applied. Incidentally, that judgment also gives a really comprehensive analysis of when communication will be political and when it will be protected. I promised Dominique I wouldn't use this forum to vent my frustrations at that judgment, so that's all we'll say about that. Moving on to have a look at the terms of the legislation, I think it's useful for us, before going on to the Act that was in question, to look at the Act that predated that, because it sets a foundation. So the Election Funding, Expenditure and Disclosures Act did a number of things, but for our purposes, it imposed a spending cap on all of the players in the electoral process. That is, larger parties, smaller parties, and third-party campaigners. Larger parties being defined as those fielding candidates for both houses in all electorates. The smaller parties defined as those fielding candidates only in the upper house, or only in the upper house with less than 10 in the lower house. And the third-party campaigners are obviously those that are seeking to influence the election without actually fielding any candidates. And you can see the caps there were at 9,000,003 for the larger and 1,050,000 for the smaller. It might sound like we're getting caught up in the details, but actually those numbers will become relevant as we move through today. So that scheme was essentially replicated in the Replacement Act, which was the Electoral Funding Act, but for two primary differences. One was to reduce the cap for the third-party campaigners, not the smaller parties, but the third-party campaigners from 1,050,000 to 500,000. The other thing it was to do was to prevent the aggregation of those things. So two or more of those third-party campaigners couldn't get together and pool their $500,000 so as to create a single campaign, either a block of television ads or what have you. It's also worth noting that that act raised the numbers for the major and minor parties by way of indexation to the figures you can see there. The purpose, the stated purpose of the Act, and there were 5 of them that were stated very explicitly, but overall the purpose of the Act was to prevent some of the corruption that had seeped into money in New South Wales electoral politics, and to sort of prevent the drowning out of smaller interests by larger wealthy interests, essentially to create an even playing field for discourse leading up to elections. Question might be asked as to why there were different caps imposed for different entities. And the answer to that was that major parties had to field all candidates in all electorates on all issues, whereas the smaller parties could be very strategic about where they chose to field candidates, and the third parties would sometimes have only a single issue on which to campaign, and therefore there was a much reduced level of expenditure required. That still leaves us with the question of where this $500,000 figure came from. The answer to that is there were 2 inquiries that were conducted. A panel of experts were convened who in 2014 tabled their report which suggested this reduction to $500,000. Following that, as governments are wont to do, they had an inquiry into the inquiry. And the Joint Standing Committee also released a report which reaffirmed that suggestion of reducing the figure to $500,000. The reason for that being they were looking to avoid the influence of these PACs, these political action committees that had become so powerful in US politics. Now, in sponsoring the bill, the Special Minister State cited those reports, particularly the expert report, as the sole source of evidence for that $500,000 figure. Interestingly, though, both of the reports had suggested that an analysis be undertaken to find out whether that figure was actually a reasonable one. The panel of experts recommended that immediately following the election for which that cap had been imposed, there had been an analysis undertaken to see whether those third-party campaigners could still adequately make their case. And the JSCM report recommended before the imposition of that cap that analysis be done to make sure that they were still adequate provision for them to be a real player. Both of those recommendations were disregarded, and that again will become relevant as we move through some of the judgments. It's interesting also to note that all of the plaintiffs, with the exception of one, were incurring expenditures well in excess of that $500,000 figure. So that gives us an idea of where the legislation looks like and what it was that was under challenge. The plaintiffs had accepted that this purpose of preventing the drowning out and creating a level playing field was a legitimate one. They accepted that a reasonable way of achieving that objective was to place caps on the various players, and even accepted that to place differential caps on different players were reasonable ways of going about things. But they said that the two amendments had an additional purpose, and that purpose was to marginalise the third-party campaigners to the point where they could still participate, but not so effectively so as to influence the outcome of any election, and to privilege the place of candidates in the election process. Now, in a remarkable show of candour, the State of New South Wales accepted that. And they said, yes, that's precisely what we were doing. This privileging and marginalising is precisely what the legislation was intended to do, because the Constitution envisioned exactly that. This system of government that we have creates a privileged place for candidates in the system. They're the only ones who have to field candidates, contest elections, run governments, and because of that, they're entitled to a privileged place. They also said, this isn't a contest about principles, this is a contest about the dollar figure at which the Parliament arrived, and that dollar figure is within the margin of choice that is open to the Parliament, and that the appropriate move for the court there is to defer to the Parliament and take a hands-off approach. There was also another argument by the Attorney General of South Australia intervening as they're entitled to do because of provisions of the Judiciary Act. And they argued that a lesser degree of scrutiny was required in state electoral matters as opposed to the Commonwealth matters. So those are the positions of the parties. Now if we move on to have a look at the judgments, and we'll start with the judgments of Chief Justice Kiefel, Bell and Keane, who almost always work together in constitutional cases, particularly in implied freedom cases. And they looked at this argument about the privileged place of candidates in the Constitution and dismissed it out of hand instantly. So there's no such provision and no constitutional position for such an argument. And then, keeping in mind that second limb of the Longy test, they said when you're looking to purpose, if it's an efficient way of resolving the issue, you can take the purpose as the purpose that's argued for by the parties. You can sort of take them at their word and then move on to resolve the questions that are really at issue here. And in doing so, they moved on to that reasonably and appropriately adapted arm of the Longy test and said the only way to determine whether that was or wasn't the case was if some evidence had been tendered to the effect that the cap was necessary. And in this matter, no such evidence was tendered, and there was therefore no way for the court to determine whether the $500,000 figure was a rational one, and on that basis the legislation was doomed to fail. Moving on to Justice Gaygler's judgment, he took a slightly different approach, and he was the only one who really engaged with these ideas that were argued by South Australia, and again dismissed them out of hand with a deft flick of the wrist, as Gayglers want to do from time to time. He also looked at this argument by the joint judgment that you could take the party's word for it. That is, you could assume the purpose from what it is that the State of New South Wales had argued was the purpose. And he said that the Constitution allows for no such thing, and that in determining matters like these, the court must be satisfied of every element of every fact relevant to the determination of the matter. And he said that if questions are raised about legislation, it is for the state, the imposing party, to demonstrate the necessity of doing so, that the onus is upon them. And he looked at this argument about whether it was within the margin of choice for the legislature to impose that, and he said, yes, that's ordinarily true. And in most situations, the legislature isn't required to justify itself unless there is an argument about the implied freedom, and in that case they must justify that what they've done is within this reasonable spectrum whereby they've done no more than balance the competing interests. So in that case, if the implied freedom is being competed with by the need to have open and honest elections, then it must be demonstrated that the law does no more than is reasonably necessary to achieve that. And he said the only way to do that would be to demonstrate that the cap still allowed the third parties to compete. And that isn't implicitly obvious, that isn't self-evident from the $500,000 figure itself. And if that's the case, the imposing party must demonstrate the necessity. And in this case, since they'd failed to do so, in fact, they declined to lead any evidence to that effect, again, the legislation must fail. Moving on to Justice Edelman, and his judgment starts with what might be one of the greatest lines, opening lines in a constitutional judgment ever. He says, absolute freedom for the pike is death for the minnow. So you can probably assume where his judgment's going from that. He took a slightly different approach though and said this isn't about whether this law is reasonably and appropriately adapted to a legitimate interest. He said the legitimate interest, the purpose, is really the question here. And the question is whether the purpose of silencing some interests in the aim of bringing up the voices of other interests in the process is a legitimate one. He said this third question of reasonably and appropriately adapted can only exist after that first limb of the second Lungy test has been established, and that cannot be answered by in response to the judgment by assuming so from the parties, nor can it be done by simply reading the Act itself and the generalities that are argued there. It is a job for the court to look into those purposes. It is a job for the court to determine those things for itself by currently investigation. He noted that it will be very rare that a piece of legislation has as its purpose infringing the implied freedom. But if ever it does, it will automatically be illegitimate. It will automatically have to fail because it cannot be consistent with representative and responsible government. He argued that 29 and 35, the two pieces of legislation in question, were amending acts. And had they been written from scratch and this $500,000 being imposed as opposed to reduced, we might be having a different question. But since this was an act of reducing a pre-existing cap to a new level, it must be somehow demonstrated that this drowning out that the Act was so desperate to prevent was actually occurring. Otherwise, no evidence existed that that the reduction was necessary. And in this case, no such evidence, as I say, had been tendered. So that leaves us then with the question of what does it all mean for us? Well, it's easy to speak in terms of what it doesn't mean. It doesn't mean that there is something unconstitutional about the imposition of spending caps. That question had been asked and answered in previous cases, and they're perfectly legitimate. It doesn't mean that spending caps can't be imposed on different parties at different levels throughout the process. It doesn't even really mean that $500,000 is a constitutionally impermissible dollar figure to come up with. What it does mean, though, is that at whatever figure the legislature arrives, there must be some evidence to demonstrate the necessity of it and the reasonableness of it, and that it was done so with a legitimate purpose in mind. As I say, that we could talk much more here, but I think I'll leave it there for the moment, and we might have some time for questions afterwards. Thank you very much.
We need to change them, but we can do that. That one. There we go. Hopefully that will work. Good afternoon, everyone. My name is Philip Green. I was the ACT Electoral Commissioner from 1994 to 2017.
That's what the bio says.
Good. We started out getting our facts right. I would like to acknowledge the traditional owners of the land on which we meet, the Ngunnawal people, and give my respect to their elders past and present. So I'm going to be talking about what am I going to be talking about? I'm going to be talking about the ACT example of how public funding, donations, expenditure caps, and all the things that Benjamin's just been talking about apply in the ACT. and looking a bit at how the Commonwealth laws differ and intersect with the ACT laws, and recently very seriously intersect with the ACT laws, because there's now been a piece of Commonwealth law that seeks to override state and territory disclosure laws, which has made things a bit more troublesome than they might have otherwise been, given that our topic is how troublesome are these laws. So a very brief history of funding and disclosure laws as they've applied for federal and ACT elections. The very first funding and disclosure laws were adopted by the Commonwealth as part of the 1984 electoral amendments that came after the Hawke government was elected in 1983. And we have three people in the room who were involved on those amendments. Michael Maley, Bill Maley and myself were all part of the team that worked on the 1983-84 amendments to the Commonwealth Electoral Act, although we weren't responsible for the disclosure side of things. Bill worked on the public funding side of things. And Michael and I did things like Senate count and exciting things that were interesting. I have to tell you that funding disclosure is my least favourite part of electoral law. Just I'll put that on the table right now. In those days, the disclosure thresholds were quite low. They started at $1,500. And the ACT modelled its funding and disclosure laws on the then applicable Commonwealth laws when the power to run its own affairs was given to the ACT Legislative Assembly in 1994. So the first set of ACT laws effectively mirrored the Commonwealth laws because the Commonwealth law had a reasonable threshold for disclosure, and the laws at that time were reasonably tight in what they controlled. But in 2006, the Howard Liberal National Party government increased thresholds for disclosure to $10,000, indexed, and then currently they stand at, I think for this election, at $13,800. There are people in this room who probably know more about these things than I do. So if I get any of my facts wrong, given that I've been retired for the last 2 years and not taking a lot of interest in this area, please correct me on my facts. So as almost a direct result of the fact that the Commonwealth became so out of step with the ACT set its own threshold, and rather than stick with 1,500, the ACT actually decided to go down to 1,000, and we've stayed at 1,000 in the ACT ever since. That's not indexed. So the current ACT campaign finance scheme has effectively 4 different arms to it. There is a public funding arm. We have caps on electoral expenditure in the ACT. There are limits on anonymous gifts in the ACT. And there's disclosure of the financial transactions of a whole bunch of political entities, including registered political parties, members of the Assembly, associated entities, which is a similar kind of body to the Commonwealth associated entity, which is something that's connected to a party but not actually part of the party. Candidates, both party candidates and non-party candidates, third-party campaigners and broadcasters and publishers. So there's a whole bunch of reporting that goes on almost all the time now with the way that the ACT law works. Public funding started out being based on the Commonwealth model, and I think we started out with amounts that were similar to what was being paid in the Commonwealth. I think when we first started it was $1 a vote. Dredging back my memory to 1994, that was a long time ago now. That was increased to $2 a vote at the 2012 election, and then it was increased to $8 per vote in the 2016 election. A fourfold increase, that's higher than the Commonwealth pays now, although the Commonwealth does pay an amount for House of Reps and Senate elections, so if a party gets, that's 2 amounts per vote per person, if you know what I mean. To achieve that, as with Commonwealth elections, they have to achieve 4% of the number of informal votes in that electorate, either for the party as a whole or if they're non-party candidates in their own right. Of course, we all know that the ACT has multi-member electorates using single transferable vote. So that is a difference between us and Commonwealth House of Reps elections. And we also have something, I don't know whether any other jurisdictions have this, but we pay administrative funding to parties with representation in the Assembly. And to any... Sorry?
A couple other states.
A couple others do too, okay. And at the moment that stands at $22,745 per year per MLA gets paid to the party for administrative expenditure. And we have caps on electoral expenditure. I can tell you why these amounts are at these amounts. So the caps that we have, or that applied at the 2016 election, were $40,000 per candidate to a maximum of 25 candidates, which means that Labor and Liberal, who each ran 5 candidates in each electorate of the 5 electorates, could spend $1 million. If they were a non-party member of the Assembly or a non-party candidate, the limit was $40,000. The limit on third-party campaigners was $40,000, and the limit on associated entities was $40,000. Why did we have $40,000? Given that that was extremely relevant in Benjamin's presentation, I'll talk a bit about that. The limit in 2012, when the expenditure cap was first introduced, was $60,000 per candidate. And they arrived at that amount by saying, well, at that point we had 17 members to be elected in the Assembly. They said at the 2008 election, Liberal and Labor both spent round about $1 million. Divide 17 into $1 million and then round it off, you get about $60,000. So it was effectively coming up with an amount that was equivalent to what had been spent. So it was basically saying, well, we're not going to make Labor and Liberal any worse off than they currently are, and let's come up with a number that keeps us happy. But then when you divide that into each MLA or each candidate, if you're running fewer candidates than 25, the cap drops all the way down to $40,000 now that we've got 25 members, which is not a lot of money. And when you apply the candidate cap to a third-party campaigner or an associated entity, that's a really tiny amount of money if you want to have a serious impact on an election campaign. And the fines that we've imposed for people exceeding the expenditure cap were third-party campaigners who'd taken out a couple of ads in the Canberra Times, and before they'd know it, they'd spent more than $40,000. And then we said, oh, we've just noticed we put some ads in the Canberra Times. Did you know there's an expenditure cap? And they went, no. How much have you spent? More than $40,000. That quick, that easy, and my personal view, and I'm pretty sure that we put this in our report to the Assembly when I was responsible for drafting these things, was that I think that $40,000 for a third-party campaigner infringes the constitutional right to campaign, because it's such a small amount of money. So I'd be very interested in that one going into the High Court as well, as if anyone cares enough about the ACT to take us to the High Court, but that's another thing. Sorry, just joking. So we also have limits on anonymous gifts. Anonymous gifts up to $1,000 each may be received, but only up to a total of $25,000 altogether. And essentially that's there to cover fundraising events where people just stick money in a bucket that's being handed around. It's not intended to be a way of getting around the disclosure rules. It's really meant to be a way of recognising that in some instances parties get money that they don't know where it comes from, but it's not in large amounts, and it's capped at a total of $25,000. By contrast, if I understand the Commonwealth law correctly, their limit on anonymous gifts is the $13,800 expenditure cap threshold, and you can receive as many of those as you want. So you can have an awful lot of anonymous gifts. Is that?
It actually changed through the Foreign Donations Bill Act, and now there's a limit on anonymous donations, particularly because you need to be able to check that donations over $1,000 aren't from a foreign donor.
Okay, good. That's a good thing. And if you receive anonymous gifts over these thresholds, then they're payable to the Territory. I'm not aware that that ever happened, but the threat of it was enough to prevent that happening. I have colleagues in the ACT Electoral Commission that I'm looking to for nodding every now and then, and there are Commonwealth colleagues that I'm looking at for confirmation too, so this is why I'm looking at the audience and waiting for nods. Then we get to disclosure of financial transactions, which is where most of the work is involved as far as the Electoral Commission is concerned. So all cumulative gifts of 1,000 or more given to an ACT political entity must be disclosed. So it's a very small threshold, and it's also cumulative. My understanding is the Commonwealth has a much higher threshold, and you look at individual gifts, you don't cumulate. Is that correct?
It's complicated.
You're right. Okay. It's complicated. That'll do.
It depends on whether it's from the perspective of the donor or the party.
Right. It's complicated. I think you're all understanding that this stuff is just complicated. That's basically one of the reasons why I don't like it very much. The current law has effectively gifts being reported quarterly, except in the lead up to an election, when from 1 July up to polling day, which is a fixed term, the third Saturday in October every 4 years. Any gifts received within 7 days have to be disclosed, and then the Electoral Commission has to put them up on their website within a few days of receiving it. So typically it's up within 24 to 48 hours. So that is almost real-time disclosure of receipt of gifts. And we also have annual returns, not just of gifts, but also all other kinds of receipts and so forth. And these are published in the first week of September, which is a date chosen to mean that the annual return in the year just before polling day gets published before polling day. Commonwealth still has their disclosures published in February. Yep. So if you have an election any time between the end of the financial year and February, you don't get to see the returns for the year before the year that you're currently in. So there's a real gap in the way that the Commonwealth disclosure happens. So, as we've been discussing, there are quite significant differences between the Commonwealth and the ACT disclosure schemes. The thresholds are very different. And the law is a bit more complicated than I might have thought on the second dot point there. And I think I'm right in thinking federal gifts given to different branches of the same party is treated as separate transactions. So you can give a whole bunch of gifts of $12,000 or even $13,799 to 8 different branches of a political party, and you don't have to be disclosed in disclosure returns. There are no federal expenditure caps. That's still correct, isn't it? Yes, good. And we just talked about the anonymous gift thing as being a bit more complicated than that. And we, in the ACT, publish disclosure returns in a much more timely fashion than the Commonwealth does. So just to give you an example of how those differences apply and what you get to see in returns published by the ACT compared to returns published by Feds. In 2017-2018, the most recent annual returns that are available, both the federal returns and the ACT returns disclose total receipts of 752,627 from the ACT Liberal Party. In the federal return, there are 3 entities identified, and the receipts from those add up to 383,800, which is about half of the total receipts. So if you look at the federal return, half of what the ACT Liberal Party is getting is a mystery. It doesn't show you who they are. In the ACT, because we have a $1,000 disclosure threshold and it's cumulative, we have 50 entities being identified, totaling 624,000. And the difference between that 130,000 will be amounts of less than $1,000 or anonymous amounts of no more than $25,000. So you can see that the ACT law gives you a much better picture of what's going on. A lot of those entities are MLAs of the parties who are paying levies to the parties, which is not a gift. It's less than 13,800, but it's something that is now on the public record for people to have a look at. This might be the slide that Benjamin thought of was dense. This is when he commented on my presentation. So we've had the Commonwealth Electoral Legislation Amendment, Electoral Funding and Disclosure Reform Act. I love the way they call it reform. Yes, we won't go there. So these amendments came into force on the 1st of January. They are complicated, and I don't even pretend to understand them. And I'm quoting the ACT's Electoral Commission's fact sheet here. They've had the effect of limiting to a significant extent the operation of the campaign finance schemes in all states and territories, because it says something like, regardless of the state and territory legislation, Commonwealth thresholds apply unless the money is earmarked for a discrete state and territory purpose. Just in a nutshell, the law is way more complicated than that. So that has the effect of applying these much larger thresholds to the state and territory laws. A lot of the states and territories have much lower thresholds than does the Commonwealth. So it's really quite a tricky thing for the states and territories to work their way around, and the only way that I can see it under the law as it was made, that the ACT is able to reimpose its thresholds, is to set up what it used to have in 2012, which was a requirement to corral money into an ACT election account, a federal account, an admin account, and then apply. And the way the Commonwealth law would work is that the ACT thresholds would only apply to the ACT account, which is way more complicated. That applied in the 2012 election. It was so complicated that they repealed it again in 2016. We can talk more about this later if people are interested. So, banning gifts from property developers is one of the flavours of the month in this field, and the ST government has tabled a bill to ban gifts from property developers. It hasn't been debated, I don't think, yet. It's just been a bill. And just in the last couple of weeks, there's been a High Court case, Spence v State of Queensland, which has looked at the Queensland provisions banning gifts from property developers, and that case overrode or made invalid one of the two sections in that Commonwealth amendment that purports to overwrite the state and territory legislation, but it doesn't override both of them. And I don't understand the law enough to know whether that court case has overridden the issue that it applies to the ACT or not. But the ACT Commission think it has, so that would be a good thing.
They haven't released reasons.
No.
Or reasons for it yet either, so we don't know what the court is thinking. Yes, we wait to hear that. Well, no, even for the normal Benjamin, we don't know what the court is thinking.
Yes. So watch this space as to exactly what's going to be happening around these things. So when they wanted me to give this talk, they said, we want you to talk about how hard it is to administer this stuff. And the short answer is it's not that difficult. Because in the ACT, just the threat of, if you don't comply with these laws, we'll take you to court, has proven to be enough for people to do the right thing. We've never actually had to take anyone to court in the ACT for failure to comply with these laws. We have fined people, but that was through a penalty notice system. It wasn't through taking them to court. And campaign finance regulation requires a different skill set to other electoral administration roles. Most electoral tasks are fun. It's organising elections and working out the best laws to apply to those elections, and it's training people, and it's doing the technology stuff, and it's electronic voting, and then there's finance and campaign stuff, which is accounting and regulatory compliance, and as I said, it's my least favourite part of what I did for all those years. So the larger electoral commissions tended to have a body of staff who worked just on that stuff because they had the skill set of looking at campaign finance compliance, and it's basically going into parties and auditing their books and going through their electronic records and all that stuff that you have to do in the ACT Electoral Commission, because it's traditionally been a very small organisation and not a lot of staff. So rather than devote people with auditing skills as paid staff, the Commission has employed contract auditors who would go in and do the work, and that for us worked really well, and I'm assuming it still does. Yep, getting nods from people who are still there. So as I say, we've never had to prosecute anyone in court, and the threat of prosecution has proven sufficient to ensure compliance. But one thing that we did do a few years ago was convince the Assembly to pass laws that gave us the right to issue penalty notices. That's a fairly recent thing, but because there are absolute thresholds, and particularly the campaign expenditure limits, if the threshold was $60,000 as it was in 2012, and someone spent $70,000 and they admitted that to us, and there's no dispute about the fact that they'd spent that amount of money, the law allows us just to issue them with a penalty notice for the calculation that applies to that. I think it's twice the amount of the breach gets paid as a fine. So if they overspend by $10,000, they have to pay a fine of $20,000. So We've had fines for exceeding the expenditure cap issued, I think, both in 2012 and 2016. And I think it was the case I mentioned earlier, or like the case I mentioned earlier, where someone had spent the money before they even realised that there was a cap, because the cap for third-party expenditure is such a low amount. And we did fine the Canberra Liberals $16,500 in 2013 for persistent failure to declare gifts on time. We really tried very hard to get them to disclose on time, but they, for internal reasons of their own, didn't do that. So that's probably the biggest fine I think we've ever levied on a political party. And there were 2 further restrictions placed on things in 2012, where only enrolled ACT electors were able to make donations to ACT political entities for ACT election purposes. So this is where we had an ACT election account. So into an ACT election account could only go money given by ACT electors, and only money from that account could be used as expenditure on an ACT election campaign. And we also had limits on a donor could give no more than $10,000 in one financial year to an ACT political entity for use in ACT election expenditure. So again, that went into this ACT election account. Didn't prevent money going to Commonwealth purposes or administrative purposes, so it didn't offend people's ability to give as much as they wanted for Commonwealth election purposes. But it did mean that we had fairly complicated requirements on parties to keep separate accounts for all these things, which they found quite painful, and for various reasons, and that being the painfulness being one of them, those elements were repealed before the 2016 election, so they don't currently apply. So getting to the topic of our question, and how much, I've probably used way more time than I should, but anyway, I always talk too much, so sorry about that. Is it troublesome? So for administering it from an Electoral Commission's point of view, I've never found it troublesome other than it was just painful. The fact that we held formal audits routinely and regularly meant that compliance levels were high. In our early years, we didn't do regular audits every 12 months. Stakes were a bit less in those days, but in recent times there's more and more spotlight has been on this stuff. The audits have been held regularly, and they've worked routinely to make sure that disclosure does happen when it should. That said, if political entities were to operate illegal finances off book, us sending in auditors to look at their books isn't going to find that. And that's an issue that would require a lot of resources to go and find, which the ACT probably doesn't have. But if you look at the amount of spending and you compare that to what the records are showing as being the incoming, if someone's spending a bucket load of advertising and whatever, and there's no apparent source of funding for that, that's something that would become apparent as time goes on, and I don't think there's any evidence of that in the ACT. But the fact we have different disclosure levels at federal and ACT is something that I think is troublesome. I think, and I would argue that a $13,800 disclosure threshold, the way it operates in the Commonwealth, means that people can get away with donating quite large sums of money without having to be disclosed. So I think that's an issue. I think that's troublesome. Whether or not the court cases sorted out this most recent bill, depending on the answer to that, that may be more troublesome or not than we currently know. And now we're getting to the bit where I'm going to stick my neck out, because I'm retired, and I should have said right at the beginning that anything I say has got nothing to do with the ACT Electoral Commission, because I don't work for them anymore, and I haven't done for 2 years. So don't blame them for anything that I say. So we've got moves to ban donations from property developers in New South Wales, Queensland and the ACT. And if you look at what's being written about the government's doing those things, they're indicating that there is a clear perception that donations from property developers have the potential to corrupt the political process, and effectively that's been agreed by the High Court, where it's upheld bans on developers, money given from property developers. So if this is true of property developers, why is it not also true of everyone else who gives money, big money, to political parties. Gambling interests, alcohol and tobacco, mining companies, banks, media companies. You would only give a lot of money to a political party if you thought there's something in it for you. I think that's troublesome. That's just me. So, how could we fix that if that's an issue, and an issue that needs fixing? I've thought for a long time that if we had national standardised disclosure laws where every jurisdiction had the same thresholds and the same publication dates and the same rules applying to them, that you wouldn't have this issue about one jurisdiction being less rigorous than another. And if it's to be effective, you'd need low thresholds. I think expenditure caps are a good thing. You've just got to look at Clive Palmer trying to buy his way into the parliament at this very election. That, to me, is an issue. And you've got to do it frequently. The way that the Commonwealth does it, disclosing it in the February for the financial year that ended at the 30th of June, that's not disclosure that's in any way timely or useful for people, particularly if an election happens in the meantime and you can't see who it is who's been giving money to the parties that you're voting for. And then I think it's time to address the elephant in the room and limit or ban donations to the extent that political entities do not feel beholden to donors. It seems to me that parties get so much money from their various corporate donors that it's very hard to look at them and say, well, are you really not believing the climate science, or is there another reason why you're against cutting back on mining coal or whatever the example might be? And if you're going to do that, then you're going to have to increase public funding of elections. But I also have trouble with the way that works, because you give lots of money to the big players and you give not a lot of money to the small players. And it means the small players find it really hard to compete. And if you start limiting the donors and not giving them lots more public funding, that's an issue. I don't have an answer to that. So, we've arrived at the end. We're dreaming the impossible dream. I think the real trouble with campaign finance laws is that the laws intended to regulate campaign finance are made by the same entities that the laws purport to regulate. It's a self-regulating environment. We know how that worked out with banks, don't we? And there's a conflict of interest that's just built into the very notion that legislators legislating to legislate and regulate their own behaviour. You've just got to look at the Commonwealth disclosure thresholds. And it's a clear indication to me that the people making those laws are making those laws in such a way that doesn't cause them a great deal of grief. So, my impossible dream is a mechanism that would allow stringent campaign finance laws to be specified and applied independently from political chicanery. Look it up in the dictionary, it's a good word. And the only way to do that at the Commonwealth level is a constitutional referendum, and I don't think that's ever going to happen. So this is why this is an impossible dream. There we go.
Whatever takes your fancy. Yeah.
I was reminded of a conversation about 35 years ago from the mention of funding for parties' administrative expenses in the ACT. We had a discussion with the then Deputy Electoral Commissioner, Andre Cyrillus, back in the 80s about whether there was a constitutional head of power for the Commonwealth to fund political parties, as distinct from funding activities to do with elections, for which there's a clear constitutional head of power. He then referred to the Australian Assistance Plan case, which was saying the Commonwealth could spend money on anything, but a lot has changed since then. And I know you've worked on this, Dominic. Is there a view on whether the Commonwealth could, in fact, fund political parties at the Commonwealth level?
I'm not aware of any recent published views on that, but I will admit that it's not something that I've looked at recently. Just thinking it through from first principles, I'm not sure that the AAP case is as solid an authority for that proposition now as it was back in the 1980s. And I think you might struggle to find a source of constitutional power that would allow the Commonwealth to set up a political party as opposed to something that was administering an election. Because it wouldn't obviously come under any of the incarnation of the executive power under Chapter 2 of the Constitution, and it doesn't fall easily within any of the enumerated powers in Section 51. Then again, you know, the Wilkie case tells us that there are really novel things you can do with powers like the Census and Statistics one. So I'm not ruling it out, but it would be much more of a stretch. There have to be some very clever constitutional thinking. I would have thought. Ben, did you want to chime in case I missed something?
And I've never thought about it before. It's just off the top of my head. Maybe nationhood, something that's particularly adapted that only a federal authority could do. And if you argued that that this had reached a sort of crisis level, this kind of funding in politics.
I think it'd be a real to regulate. Yes, I think you could possibly. I have some thoughts about Phil's impossible dream and how you might be able to do it without constitutional reform. A regulator you might be able to get under that head of power, but a political party I think is a different beast altogether and harder to justify under nationhood grounds. But that was constitutional analysis at speed. Sorry.
Yes, I have a vague recollection on this particular point that the advice of the Attorney General's Department was sought on this point, and even in 1983 they declined to say with confidence that relying on the AAP case one would have a constitutional basis for funding political parties. But I actually wanted to ask Phil, this is a kind of thought experiment, what kind of politics might one end up with if you had tight restrictions on donations and disclosure and no public funding? It might actually force political parties to go back to developing expansive bases of memberships which have been shrinking dramatically. I remember somebody remarking to me not long ago that the entire membership of the ALP nationwide was less than the membership of the Hellenic Club in Woking. If indeed that's true, then it's not surprising that political parties are becoming more and more patronage networks rather than transmission belts in a kind of Sartori model between the public and the political process.
Yeah, so if we restricted donations, capped expenditure, and didn't have public funding, they're going to not have a lot of money to spend in their own right. So I would imagine that then you get your third-party campaigners wanting to spend money directly, so capping expenditure from them would also need to be in the mix, but it needs to be capped at a level that's constitutional, which is an interesting issue. They'd be looking for free ways of advertising. So you get more and more in your social media feed of things where they're getting stuff out there that doesn't cost a lot of money. Another issue, there are other problems I have with the way the law currently works at the moment, is the advantages that members of Parliament get from being members of Parliament. They get all these free allowances to send letters out extolling how good they are. And they get all this travel that gets given to them for free up until the point where the campaign commences, and you'll notice that they have their official campaign launches after the writs are issued, so that even when the writs are issued for an election and they're campaigning like mad, they're still getting public funding of all their travel around the country because the campaign hasn't been launched. I mean, if that's not a self-regulation failure, I don't know what it is. So you're getting less and less of a playing field the more and more you're giving money to the ones who are already there. The world's changing the way things are advertised these days, but that does cost money to get out there and advertise stuff. So if you're limiting what people are learning from social media and newspapers, which may or may not have an independent bent, what kind of message are voters getting from their people doing their political campaign? I don't know the answer to that, but there's a whole bunch of issues tied up in that question. others may well have views.
Just a comment on that and then a question. If you compare the political finance scheme in Australia to sort of other comparable sort of Western democracies, one of the things that you notice in a lot of other countries is bans on political advertising. And we tried that, and that's how we ended up pretty much with our implied freedom of political communication. And that's sort of one thing that obviously complicates it. But just in relation to a question, if you look at, I mean, Phil talked about where the cap came in New South in ACT, and it was like the parties like, well, this level won't really inconvenience us. In some of the discussions around the New South Wales panel of experts, you know, there was talk about how to set the threshold, and pretty much the threshold that they came up with was one that wouldn't inconvenience the major parties. South Australia, where they have the opt-in public funding scheme, which also involves an expenditure cap. There's no evidence of how they came to that, but it looks like the parties had agreed with it behind the scenes, and put it forward as sort of like a fait accompli, because it wasn't really debated in the South Australian Parliament. Certainly the levels of the cap weren't really debated. So it seems like where we do have caps that were set at a point where they won't really inconvenience the major players, and the argument around the drop of the New South Wales cap to $500,000, one of the bits of evidence that it was inappropriate was it was inconveniencing some of the players, some of the third parties. And so I'm just wondering what sort of evidence we need to, might the High Court be sort of happy with as to how you set a cap if all our experience so far is you set a cap at a level where it's not going to inconvenience anyone, which essentially makes it pretty useless.
I don't know. I think the question wasn't that the cap was inconveniencing anyone. The question was, how did you arrive at that metric? Now, I would imagine a clever government could kind of convene a panel, scope an inquiry in such a way as to kind of almost require the answer that you were looking for. And were you to have conducted that kind of analysis, then there's a reasonable chance the court would accept that process. I think the court's issue here was more about process than it was about the figure at which they arrived, and it was less about whether anyone was inconvenienced and more that both of the panels had specifically recommended this analysis and that had been sort of disregarded. Had they undertaken that analysis, and anyone knows that you can conduct your analysis in any way you please to get the answer you want, then the answer would quite probably have, or the figure would quite probably have been legitimate. Being that the pre-existing figure had been agreed and was constitutionally fine. So you know, I think it's a matter of process rather than figure.
I might add that a good test of whether a cap is a good cap might be if it does inconvenience people. Come up with something that parties mean they've got to spend less this election than last election. Might be a better cap. Again, I can't see them buying that, but it's one way of thinking about it.
Question for Ben. I think one of the interesting things about unions was the extent to which the court asked questions about the internal processes of Parliament's deliberations, sequence of inquiries and so on and so forth. This strikes me as very unusual. I was wondering if you think it's unusual and what it noting that this whole body of law has started asking questions about purpose and therefore an inquiry does seem to make sense. But a lot of what happens inside of Parliament does not happen for rational purposes. Contain your surprise. It's the cutting of deals and compromises and things that were debated, not weren't genuinely debated anyway. Is the court perhaps taking us down the wrong pathway in imagining that there will always be a rational purpose to be found?
Good question. You know, the history of this implied freedom and the history of cases that seek to kind of regulate elections, to Roach and Roe and those kinds of things, is that it's almost impossible to second guess, and that in terms of when the court will and will not insert itself, it seems particularly dependent on membership of the court at the time, the severity of the intervention. So I'm not sure whether I think it's wrong for the court to assume a rational purpose. I think, you know, it's when you look to legislative purpose, it isn't trying to get inside the minds of the people sitting in Parliament. It's the purpose that appears from the page, or the purpose that appears from the legislation. And so when Justice Gaygler or Justice Edelman say the court will inquire for itself about the purposes, it's what can be defined from the terms of the Act, as opposed to what might have been the thinking of the 127 people, whatever it is, sitting in Parliament or sitting in any of the one houses at the time. So it's important to not confuse legislative purpose with actual personal or parliamentary purpose, I suppose.
But I will say that it is frustrating that the High Court has not given us a very clear indication of when they will delve into the parliamentary record and when they will purely do it on the words of the statute. This isn't one of my particular irritations. And I would say that I can't predict from one case to the next when they are going to refer to a parliamentary committee inquiry process. I know that they do sometimes, but not always. And when they're going to say no, it doesn't matter what was said in Parliament. What we look at is the term of the statute. So it's just the High Court has not made up its mind or set any really clear parameters about when it's going to do that and when it's not.
Can I ask a quick follow-up on that? But one of the things that a lot of these recent legislative efforts, including the Commonwealth, have shown is they're replete with objects clauses, and there's the EMs and so on. And if, as you know, the court is looking at the legislation, well, governments have been attempting to, you know, show their working in the legislation through things like objects clause and probably to a lesser extent EMs. But in this case, my understanding of it, the court said, well, you have your objects clause and it says this is why we did it, but your actual thinking behind that, which was not expressed in the legislation or wouldn't necessarily be in the legislation, was inadequate. So we don't think your reasoning's adequate.
I think it was more a matter of saying, okay, there is this statement at the front of the Act that expresses in quite clear terms what it is that it's trying to do, you know, to reduce the incidence of corruption, to create a transparency for political spending, to create a level playing field, that kind of thing. But the question is more, well, I could have kind of gone more into some of the judgments, but Justice Edelman particularly says it's not what you state as the purpose, it's what it looks like the actual Act is doing that is its purpose. So you can craft kind of a beautifully written explanatory memoranda or set out at the front of the Act a section describing what it intends to do. But if that doesn't match what the Act actually does, then that's where legislative intent and the ambiguity between those two things will sort of come under scrutiny. And in this case, it seemed clear, and again, I could have sort of spoken more to that, but throughout the course of both of these inquiries, what both of the panels revealed was this ongoing kind of chagrin and phobia on the Conservative side of politics about the unfair advantage that unions were giving to Labor governments. Whether Labor governments actually had an unfair advantage and whether unions were responsible for that, there was no real dissemination of. But so the fact that there was this underlying thing that seemed to permeate the writing of the Act, but remained unmentioned in terms of all of those extraneous materials you're talking about, probably gave the court pause. Does that sort of answer your question?
Yeah.
Last question?
Yeah, just a quick one. Does anyone think that the spending by Clyde Palmer might be an impetus to look at cap at the federal level, hopefully?
Well, I mean, I think more important for me is where that money came from. But yeah, I think that's kind of a separate issue, actually. But you might have another thought about that.
It's certainly causing disquiet out there. I would imagine it's something that the Joint Standing Committee on Electoral Matters is likely to look at. It'll open up cans of worms for other people, so it depends whether the conflict of interest inherent in politicians regulating their own behaviour means that they think it's a good thing for them or not. That's what it might boil down to.
All right, Michael, you have, was that one last comment?
Just one last comment is that electoral law, it seems to me, is particularly replete with these situations where a statute may have an ostensible justification which is hotly disputed by people on the other side. For example, if you had rural weighting of votes, as there was for many years, this was said to by one side to provide better representation, and by the other side to distort the system in favour of one party. Similarly, requirements for production of voter identification and polling are extremely controversial in America, because is it to enhance the integrity of the electoral process, or is it to suppress the votes of minorities? And I think there's a lot to be said for the court not just taking at face value the protestations that particular reforms, in inverted commas, are really benign when they may be malignant. I just wanted to throw in one more observation, and that was, we keep seeing this figure of 4% coming up, and it came up as the baseline that the party needs to get in order to get public funding, which is also what you need to get your deposit returned. My anecdote from that was that I was told back in 1983 to research what level of deposit, what level of vote would have been required to make sure that the Australian Democrats got their deposits back right across the country, the balance of power in the Senate, and the miraculous figure which came out as 4%, which now has morphed right through the electoral system, and that's where it came from.
And on that note, could I please ask the audience to thank our incredible panel of speakers. Thank you for attending today. I hope you found it enjoyable, and please keep an eye out for the next Electoral Regulation Research Network event that we hold. Thank you. Well done. Thank you so much. That's all right. That was wonderful. I hope never to have to ask you about financial disclosures ever again, Phil. Next time I'll ask about something that you do like doing. Yes.
Sure. Any